Hello, my name is Chris Shulman. This video is the result of a collaboration amongst several Florida court-appointed arbitration trainers. As you may know, Florida statute section 44.103 creates an alternative dispute resolution mechanism for actions that are pending in court. This is called non-binding arbitration. Once a court refers the action to non-binding arbitration under the statute and the related rules of civil procedure, an arbitrator is appointed and conducts a short hearing with the parties about the merits of the case. As the statute provides, this hearing shall be conducted informally. Presentation of testimony and evidence shall be kept to a minimum, and matters shall be presented to the arbitrators primarily through the statements and arguments of counsel. Thereafter, the arbitrator deliberates and renders a non-binding arbitration award, filing it with the clerk and serving it on the parties. The parties will then have 20 days thereafter to decide whether to accept the award, in which case the award becomes binding, or to reject the award and instead to request a trial. Please note, failure to reject the award timely constitutes acceptance, and the court will typically enter judgment based on the award. If either party rejects the award, then a trial will take place. Depending on the outcome at trial, the party who rejected the award may have to pay the, quote, arbitration costs, court costs, reasonable attorney's fees, and other reasonable costs such as investigation expenses and expenses for expert or other testimony which were incurred after the arbitration hearing and continuing through the trial of the case, unquote. That's all as described in Florida statutes, section 44.103 sub G. This video is intended to orient the newcomer to the non-binding arbitration hearing process. During the next hour or so, we will first go over some of the pre-hearing processes that arbitration requires. We will then show a mock non-binding arbitration hearing, and will then conclude with the arbitrator, Rodney Romano, discussing his deliberations and his eventual non-binding arbitration award. Please note, the hearing in this video entails a single arbitrator and is conducted over Zoom, as are many of the non-binding arbitration hearings at the moment. It's the experience of all of us arbitration trainers who are involved in this video that the content of hearings, whether the hearing is conducted by Zoom or in person, is essentially the same. Now let's turn to the pre-hearing processes. Once the arbitrator is appointed, they and the parties, although it's typically the parties' lawyers, must identify several things. First and foremost, they need to pick the hearing date, time, and mode. By mode, I mean whether the hearings will be in person or by Zoom or the like. Next, they need to determine whether the hearing will consist solely of attorney argument and exhibits, or whether there will also be witness testimony taken. Please note, witness testimony is very rare in this non-binding arbitration process. Instead, if a party thinks that the arbitrator needs to hear from a witness, that party will submit a deposition transcript or an affidavit or a written statement or the like. Finally, though, the parties and the arbitrator need to decide when the parties will exchange with one another the exhibits that they intend to submit to the arbitrator. Some arbitrators, such as the arbitrator in the video we're about to see, do this process through a series of emails or phone calls, which they then confirm by email or in writing. Other arbitrators, like me, do this process through a Zoom or telephone pre-hearing conference and issue an order afterwards, spelling out what has been agreed to about the hearing. Either way, most experienced arbitrators send the parties written confirmation of the arbitration details, often providing additional information about the arbitrator's expectations for the hearing. There are examples of these kinds of confirmations among the written materials that accompany this video. We will now turn to the non-binding arbitration hearing itself. Please note that not only the arbitrator and the attorneys, but also the parties themselves will attend the entire hearing, as required by Florida Rule Civil Procedure 1.820. Often, if there's an insurance adjuster associated with the file, the adjuster will also attend the arbitration hearing.
Hello, counsel. Could we begin by asking you to announce your appearances in this case of Jones versus Stevens?
Good morning, Mr. Romano. Jessica Bartel here on behalf of the plaintiff, Tom Jones, and I have Ms. Jones present as well.
Thank you. Mr. Miller?
Morning, Dorsey Miller for the defendant, Ms. Cat Stevens, who is here, as well as the insurance adjuster, Chris Shulman.
Thank you very much. This is a non-binding arbitration and not a mediation. And at the time we scheduled it, we sent out a set of guidelines so that those who are unfamiliar with non-binding arbitrations can maximize the value of this process. The way we proceed is counsel for the plaintiff will give an opening statement, a lot like you do in a mediation, but you'll also, in addition to the mediation, refer me to the various documents and excerpts of those documents that you provided to me. I will assume that I have complete records and that you have copied them to the other side, unless you tell me otherwise. It's very important that whatever you've given to me, you've given to the other side, because I'm prohibited from reviewing anything ex parte. So if you did that, please give me a heads up now so that we can either redact it from the record or provide a copy to the other side. Okay, it looks like everybody is here and all of the materials provided have been provided also to opposing counsel. And the process is being conducted pursuant to Florida Statute 44103 and Florida Rules of Civil Procedure 1.820. And I remind counsel to be aware of those deadlines and consequences contained therein. A lot of people think that if they don't do anything after a non-binding arbitration, then it doesn't count. It's just the opposite. If you don't ask for a new trial, then the decision becomes binding after 20 days if nobody does anything. So please be very careful to pay attention to those deadlines. The way we proceed is counsel for the plaintiff will give a presentation first and teach us all about the plaintiff's claims in this case, and direct my attention to those parts of the record that you want me to review. And when she's done, counsel for the defense will do the same thing so that I can understand the positions from both sides. After counsel for the defendant has spoken, I will provide counsel for the plaintiff an additional opportunity to make any rebuttal comments. If during either side's presentations an objection is stated, if you want a ruling on the spot, I will give it to you, but typically in order to keep things flowing, I will ask opposing counsel for their position on the objection, and then we'll move on and I will address the objection and the rebuttal to the objection in my final decision. That way we can move forward more fluidly with your presentation. So when plaintiff and defense are done with their presentations, I'll confirm that there's no additional evidence, give you one last chance to make sure you're competent. You've given me everything that you want me to have. If you haven't, we'll set a very short deadline, probably 24 to 48 hours. And then if you have given me everything, I will go immediately into my deliberations and excuse you. That way I can think about things while they're fresh on my mind. And then, although I have 10 days to get the decision filed and published to you, I generally will get it done within 24 hours. And so I'll e-file it according to the way the rules require us to do it now. And I've explained that the rules of evidence are relaxed, but that to me means, and there's not much guidance, so to me that means no authentication. If you represent that it's a complete record, I will take your word for it as a member of the bar, unless the other side objects, and then we'll complete the record. When I say the rules are relaxed, though, it does not mean you can make bald representations. So for example, if there's a witness that you haven't spoken to or deposed or even statementized, but you represent to me that you think that witness would be favorable to you, I won't consider that because I don't think that's close to admissible. On the other hand, if you have a doctor's report, that will be reliable because the doctor will be bound to what's in his or her report. And so I'll consider the report, even though it hasn't been turned into an admissible deposition. Are there any questions before we begin? Thank you very much then. Ms. Bartel, you have the floor.
Thank you so much, Mr. Romano. Mr. Dorsey, Mr. Shulman, Ms. Stevens, and Ms. Jones, thank you all again for being here. As you know, my name is Jessica Bartel, and I have the distinct pleasure of representing Ms. Tom Jones for this arbitration. If you would allow me, Mr. Romano, I'd like the opportunity to share my screen for my presentation.
Go ahead.
Is everyone able to view the screen?
Yes, I see the initial Tom Jones style.
Fantastic. So as we know, and this is a case where we have a date of loss of April 1st, 2020. It is a personal injury action involving a dog bite. First things first, I want to tell you a little bit about my client, Ms. Tom Jones. Ms. Jones is currently 33 years old. She does currently live with her mother, and that is due solely to the injuries that she has sustained as a result of this dog bite and the income that she has lost. Ms. Jones currently holds a bachelor's degree in hospitality from the University of Central Florida. Now, for those of you that do not know, UCF's Rosen College of Hospitality Management is ranked among the top 5 programs in the world. And with over 3,000 students, it is the nation's largest program. Why is that important? It is important because you will learn later on that Ms. Jones works in the hospitality industry. And it's not just a job for her, it is a career, which makes this incident all the more traumatic for Ms. Jones. Ms. Jones is a piano player at Uptown Cocktail Lounge. Again, this is a career for her. This is what she does day in and day out. And you will learn later why the injuries that she sustained affected her career and her life so much. Ms. Jones earned $600 a week as the piano player at Uptown Cocktail Lounge. She also had a part-time job where she was earning $150 per week for a period of 10 weeks. And we'll hear about that a little bit later when we speak about the damages in this case. It's important to note that Ms. Jones had no prior wrist or hand injuries or problems before April 1st, 2020, when the defendant's dog viciously attacked Ms. Jones. You'll hear that Ms. Jones enjoyed jogging, tennis, and fishing, in addition to her first love and her first passion, which is playing the piano. Let's talk about the incident that changed Ms. Jones's life forever. Again, let's go back to April 1st of 2020, the day of the incident. Ms. Jones had been a tenant of the defendant, Cat Stevens, for several months. Rent was hand-delivered by Ms. Jones to Cat Stevens in cash on the 1st of each month. And it's important to know that this was customary. This was their general practice. And this was done by the instruction of the defendant. It was the defendant who instructed Ms. Jones to deliver the rent each month in person, in cash. Ms. Jones went to the defendant's home on April 1st, 2020, and she knocked on the back door. Again, this was done by the instruction of the defendant. This is what the defendant wanted, and this is exactly what Ms. Jones did. At that time, the defendant's vicious Rottweiler bolts out of the doggy door and attacks Ms. Jones. Ms. Jones is knocked down, and it's also important to note that this Rottweiler is 80 pounds. And as you can see, Ms. Jones is a petite woman. She is not very tall. And so she has now this 80-pound vicious Rottweiler knocking her down and jumping on her when all she was there to do was deliver the rent in cash, exactly as the defendant had instructed her so many times in the past. After she is knocked down by this vicious Rottweiler, she sustains a severe bite to her hand and to her palm. For reference, this is a photo of the defendant's Rottweiler that attacked Miss Jones on April 1st, 2020. And this is certainly a photo that the jury will see if we get to a trial in this case, Mr. Romano. Let's talk a little bit about the liability in this case. From the position of the plaintiff, it is crystal clear, and there's a few statutes that we are dealing with. First, we're going to talk about Florida statute section 767.01, dog owner's liability for damages to persons, domestic animals, or livestock. And I've bold and underlined a portion of this statute because it's important. Owners of dogs shall be liable for any damage done by their dogs to a person. That is exactly what we have here. The defendant's dog caused damage to Miss Jones's person. There's also a second statute that we are dealing with, and that is Florida statute section 767.04, dog owner's liability for damage to persons bitten. And there, I know this is a long paragraph, so just bear with me, but there are two important sections of this statute that need to be discussed here today. The first portion, the owner of any dog that bites any person while such person is on or in a public space or lawfully on or in a private place, including the property of the owner of the dog, is liable for damages suffered by persons bitten, regardless of the former viciousness of the dog or the owner's knowledge of such viciousness. The second important part of this statute, a person is lawfully upon private property of such owner within the meaning of this act when the person is on such property in the performance of any duty imposed upon him or her by the laws of this state or by the laws or postal regulations of the United States. Or, more importantly, and as applicable to this current case, when the person is on such property upon invitation, expressed or implied, of the owner. And that's exactly what we're dealing with here. Miss Jones did not set the rules for when rent was to be delivered. That was done solely by the defendant. And the defendant had many other options, especially in this day and age. The rent could have been paid via check and mailed to the defendant. That was not the defendant's choice. The rent could have been paid via some electronic format like Zelle or Venmo. That was not the defendant's choice. But both of these options would have prevented Miss Jones from being at this property on April 1st, 2020. But no, the defendant had to have it her way and wanted the rent delivered in cash and in person, knowing all the while that she had an 80-pound Rottweiler that was vicious. And we know it was vicious because Miss Jones was attacked. Let's talk a little bit about Miss Jones's injuries as a result of this incident. First and foremost, Miss Jones was treated on scene by fire rescue. Fire rescue noted in their report, and this is a report, Mr. Romano, that we have provided, that Miss Jones was suffering from profuse bleeding from multiple puncture wounds. It wasn't just one bite or one tooth. There are multiple wounds on Mrs. Jones's hand as a result of this incident. And we will see photos of those injuries later on. The fire rescue team also documented complaints of pain that Miss Jones rated at a 10 out of 10. That is as high as it can get on a pain scale from 1 to 10. It is clear from the fire report that she was in significant pain. And it is, of course, to be expected after a bite from a dog like the one that we saw in the photo just a few minutes ago. The EMS report also documents very clearly that the patient was hysterical. This is a direct quote from the fire rescue report. Another direct quote, she was in significant distress. Again, as is to be expected after a vicious and violent attack such as the one that Miss Jones sustained. She was frightened. Of course she was. It was an 80-pound Rottweiler that clearly was not trained by the defendant. Additionally, she had an elevated blood pressure reading. Now, we all know from the testimony of the doctors and the treating physicians in this case that normal blood pressure is a systolic pressure of less than 120 and a diastolic pressure of less than 80. Clearly, Miss Jones's blood pressure was elevated with a reading of 160/90, which is not normal. Additionally, she had a pulse rate of 105. The fire rescue, of course, sprang into action. They treated her, they began an IV, and they wrapped her wounds. Subsequently, Miss Jones was transported by ambulance, lights and sirens, to Jehoshaphat Trauma Center. It is also noted in the fire rescue report and in the emergency room records that we have provided that her Glasgow Coma scale was 15. Now, again, we know from the testimony of the treating physicians that a GCS or Glasgow Coma score is used to assess patients' responsiveness based on 3 aspects: eye-opening, motor, and verbal responses. Now, thankfully, a 15 is the best and highest score that you can have. So thankfully, Miss Jones had a normal GCS, because had she not, this situation could have been a lot worse. Let's talk a little bit about the treatment that she received once she was transported to Jehoshaphat Trauma Center. She was seen in the emergency room. She underwent an exam, and upon examination, the emergency room physicians did note a few things. Number 1, there was a 2-centimeter laceration. Now, probably thinking in your mind, 2 centimeters is really not that big, but it is. It is for Mrs. Jones, and it is because she now is going to have to live with this scar for the rest of her life. The emergency room physicians also noted multiple puncture wounds. Again, it wasn't just 1, it wasn't just 2, there were multiple. In addition, she had right wrist pain and pain in her palm, along with the puncture wounds. Of course, x-rays were taken, and an x-ray was done of her right wrist and palm to rule out any fracture. Thankfully, she did not have a fractured wrist. However, this situation is worse because she does have a permanent scar. She was, of course, treated by the emergency room physicians at Jehoshaphat. They irrigated her wounds. In addition, the lacerations that Miss Jones sustained required 4 stitches to close them. Stitches that she's going to have to go back and get taken out. Stitches that were painful for her. She was then given Neosporin, and her wounds were dressed appropriately. She was eventually diagnosed with puncture wounds and contusion to the ulnar nerve, all of which was caused by the dog bite that was done by the defendant's vicious dog. She received a few recommendations from the emergency room physicians. First off, she was instructed to avoid unnecessary use of her hand for 6 weeks. It is important that I let you know that Miss Jones is right-handed. Her right hand is her dominant hand. And now she somehow has to avoid unnecessary use of her dominant hand for over a month. That is what she had to go through. She was also instructed by the doctors to return for follow-up, which she has. She was prescribed tramadol for the pain and Clinarol for the severe inflammation in her right hand. She filled those prescriptions and she took them as directed and as instructed for the time period directed and instructed by her physicians. Let's talk a little bit about this ulnar nerve injury because it's important. Now, the ulnar nerve is also known as musician's nerve. Why? Because it controls the fine movement of the fingers. I explained earlier how Mrs. Jones's first love, how her passion, how her career, and how her ability to earn a living is because she plays piano. That is why this attack and this injury was so severe for Miss Jones. And this is exactly why it did indeed affect her entire life and her ability to earn a living. This is just a brief diagram of an ulnar nerve injury. And we can see here where the ulnar nerve is and how it leads up into the pinky finger and into the ring finger. Fingers that Miss Jones needs to play the piano and earn a living. Something that she could not do for a period of 6 weeks. And to the right of the slide here, we have a picture of the actual injury that Miss Jones sustained as a result of the defendant's vicious Rottweiler. This is the injury that she had to deal with, the injury that she had to overcome. Let's talk a little bit about the aftermath of something that very well could have been prevented. Now, Miss Jones lived with constant and nagging pain for 6 entire weeks. That may not seem like a long time, but for someone who was suffering, it's never ending. For 6 weeks, she could not work. She was earning $600 a week plus tips. And her schedule, because she was in the hospitality industry, was from 6 p.m. to 2 a.m. on Fridays and on Saturdays, the busiest days for any hospitality worker. Additionally, she worked from Tuesdays to Thursdays. She also worked part-time, where she was earning $150 a week for a total of 10 weeks. Her total past wage claim is $5,100. For 6 weeks and then some, Miss Jones had ongoing chronic pain and fatigue, which limited her ability to play the piano. It limited her ability to do any activities requiring the use of her right hand. It limited her ability to play tennis. As you heard earlier, that is something that she loved to do. It required the use of her right hand. She enjoyed fishing. That is something she was not able to do because it required the use of her right hand. Now, Ms. Jones also is going to have future physical therapy visits for flare-ups that she will most likely encounter. And those visits are going to be at a rate of 5 visits per year for a period of 5 years. And at a cost of $200 per visit, that brings her total future physical therapy visits to a total of $5,000. Now, we also heard from her treating physician that she will have possible early traumatic osteoarthritis and a possible wrist fusion, which is a surgery to her wrist that could potentially end her piano career.
I'm going to object to that. It's both speculative and it assumes facts that are not in evidence. There's been no testimony from any provider that more likely than not, the plaintiff will require a wrist fusion in the future.
Thank you. Ms. Bartel, response?
Yes, Mr. Romano, we have provided the testimony of her treating doctor that it is certainly a possibility that she will require this surgery. So there is testimony and there is record evidence to this effect.
Okay, thank you. I'll make a note of the objection and the response and address those in my final decision. Thank you.
Thank you. In addition, Ms. Jones now suffers from a 2-centimeter scar on her right hand. A scar that is permanent, a scar that she will have forever as a constant and terrible reminder of this day on April 1st, 2020. And perhaps one of the most significant things for Ms. Jones is that she now has constant nightmares and a fear of dogs. And you've heard from Ms. Jones, she was a dog lover. So this is something that is exceedingly difficult for her to cope with. In terms of the damages, this is the list that we have compiled. We have her total past medical bills at $4,200. That incorporates the emergency room bill from Jehoshaphat Medical Center for $3,563.97. In addition to the money that was paid for prescriptions, the tramadol and the Clinaril, at a total cost of $636.03. She will require future medical care, and those expenses total $20,000. The surgery is estimated to be $15,000, and the future physical therapy at 5 visits for 5 years totals $5,000. We already spoke in great detail about the income that she lost during the 6 weeks that she was unable to work because of this injury. Those past lost wages, again, at $600 a week, in addition to the $150 a week for 10 weeks, which was her part-time job, totals past lost wages in the amount of $5,100. In terms of her future lost earning capacity, that totals $150,000. And this number is based on a work-life reduction of 5 years. It is clear that Ms. Jones did have pain and that she did suffer. Plaintiffs believe that a fair award for the past pain, suffering, disfigurement, mental anguish, and lost capacity for the enjoyment of life is $50,000. It is clear that Ms. Jones is going to continue to suffer in the future. And plaintiffs contend that a fair award for future pain, suffering, disfigurement, mental anguish, and lost capacity for the enjoyment of life is $50,000. To sum everything up, the total award that we are asking for today is $279,300, as we believe this is the award that justice and the law demands. Thank you, everyone.
Thank you, Ms. Bartel. Mr. Miller, you have the floor.
Thank you, Rodney. And first of all, let me just say hello to everyone. I'm going to take a few minutes here to share my screen.
I see the style. And
okay. All righty. Perfect. So it's my job to obviously give the other side of the coin. We obviously have very different views about what the evidence in this case shows. So let me give you this case from the perspective of the defendant. Okay, so here's what we can agree on. Number one, we can agree that Ms. Jones knocked on my client's door on April 1st. We know that Snuffles, which is my client's dog, bit Ms. Jones, as she described, on her right wrist. We know that fire rescue did show up. They provided some treatment on a limited basis at the scene and then took Ms. Jones to the hospital. We know that once there, Ms. Jones was treated and she was released with instructions. We know that there was some missed time from work. However, That's essentially where the agreement ends, because there's a lot more to this story than was just presented. Here's the rest of that story. Contrary to what you just heard, liability in this case is not clear at all. Ms. Jones didn't simply knock on the door. She pounded on the door. It's important to know when this is taking place. It was at 5:30 in the morning. And we also know, because we have the EMS report, it's a part of the materials that we supplied to Rodney, which indicates that Ms. Jones was obviously drunk at that time. And that is significant because we know that under Florida law, section 768.36 to be exact, there is something called the alcohol defense. If someone is more than 50% responsible for their own harm and they're inebriated at the time, that alcohol use is a complete bar to their recovery. We know that my client had just returned from work on this particular night. She'd worked the night shift. She'd gone to bed. And when she heard this loud banging at her door, it frightened her, understandably so. And so what did she do? She sent her loyal, protective dog, Snuffles, to see exactly what was going on. Miss Jones knew that Miss Stevens had this dog. So we heard earlier that, well, my client knew that she had this animal there, this Rottweiler. Well, she wasn't the only one that was aware of that. The plaintiff was aware as well that my client, who lives alone, had this Rottweiler for protection. And in coming to my client's home at that hour and pounding aggressively on the door, the plaintiff was clearly behaving in a very negligent manner, again, because of the influence of alcohol. And yes, there is a doggy door on my client's door. However, this is an open and obvious situation. If anyone walking up to that door could see that there was a doggy door there, and it would be reasonable to expect that if someone comes to someone's home at that time of early morning and begins banging aggressively on the door, there's going to be a response. And in this case, unfortunately, Snuffles did exactly what you would expect a dog to do in this situation. She protected her master and exited through that doggy door. Now, once the plaintiff reaches the hospital, there's something that I need to point out. Yes, it's true she was there for 6 hours, but she's not under treatment for 6 hours. She's only under treatment for about 30 minutes. The first 5.5 hours that she spends there, she's in the waiting room. And since that time, this is also significant because we heard a lot about all the things that she missed out on, all the things she can no longer do. Well, the records actually reflect that she hasn't gotten any treatment of any kind in the last 6 months, and she's not anticipated to get any additional treatment at this point in time. We know that about 6 weeks after the incident occurred, she returned to playing the piano on at least a part-time basis, and then after 16 weeks, she was back to playing full-time. And with respect to the ulnar nerve, which incidentally, the majority of patients, the medical literature bears this out, the majority of patients recover completely from that type of injury. Her ulnar nerve has in fact healed. And as for this contusion, which is just a fancy term for a bruise, that thankfully has healed as well. And then finally, there is absolutely no evidence whatsoever that the plaintiff suffers from any sort of post-traumatic stress disorder. It's not noted in any of the records from her providers, and there has been no treatment of any kind for that condition. Now, as for this claim of chronic pain and fatigue, we actually have information about what Ms. Jones has actually been able to do in the aftermath of this incident. We don't have her deposition yet, but what we do have is information that she has put out there in full view of the public on her social media platforms, specifically Facebook and Instagram. And here's what we know. We know that after this incident, she took a 5-day cruise. And while she's on that cruise, she let the folks know that she was a piano player, and they actually invited her to play in one of their lounges. And she played for 5 hours straight. And that's not all she did. She also took advantage of some of the excursions that were available to her as a member of this cruise. She went on a 3-hour jet ski excursion. And in addition to that, we know that she also enjoyed herself in some of the clubs available on this cruise. We actually have images of her, which I'll get to in a moment, holding drinks in her right hand, specifically the injured right hand, and dancing. And while she's doing all of this, she's all smiles. We also have images of her dining out and doing other things on this cruise ship, like going to the theater and enjoying the various amenities that they offer. So right here, we've got some social media images of the plaintiff. She had a different hair color at that time, but we can see her right on the deck of that ship, holding a drink, a cocktail, in her right hand. We don't even see in this angle any of the scarring or any of the other things that she's complaining about. And also on the right, we've got an image of her taken during this impromptu performance that she was invited to engage in the lounge of the cruise ship. And so that brings me to the conclusion, Rodney, that we're asking you to reach here. And I think several things are abundantly clear. One, the sole reason this happened is because of Miss Jones. Yes, it was the pattern and practice for her to hand deliver her rent to my client each month. However, it was never a customer practice for her to show up at 5:30 in the morning, drunk and banging aggressively on the door. And because she did that, and only because she did that, Snuffles did what any good dog would do. She protected her master. On any other occasion, when Miss Jones dropped off her rent appropriately, Snuffles was present. However, no attack took place, no injury ever took place. Only because of her actions on this occasion did anything happen at all. And in fact, in this circumstance, because of the hour that she chose to show up, Miss Jones was a trespasser. She had an implied invitation to come at a reasonable time and to knock politely, not again to show up drunk and start banging aggressively in the wee hours of the morning. If my client has any fault at all, which we obviously dispute, it's clearly less than 50%, maybe even as low as 25%. Also, in terms of treatment, given the lack of any treatment in the last 6 months, given the fact that she's back to using that right hand fully, she's back to playing the piano full time, she's taking trips and enjoying herself and putting that information out on social media, there's no reason to believe that she's entitled to any award whatsoever for future damages. Now, with respect to the medical bills, there's some things here again that we can agree on. We don't believe it was unreasonable for her to go to the emergency room or be seen by the paramedics. So that $4,200 in past medical bills, we would agree is reasonable. So if there's to be any award at all, it should include that. And to the extent there's a pain and suffering award, that should be limited to $1,000 a week. She was only out for 16 weeks. So 16 weeks, $1,000 a week, that would be $16,000. And we also agree, because she did miss some time, although it was limited, that she would be entitled to the wage loss claim of $5,100. So in summation, we believe, again, the evidence here strongly suggests that the verdict should be for the defense in this case. We feel like her intoxication should serve as a complete bar to her recovery. However, if there is an award, it should be no more than 25% of her total damages as calculated in the previous slide, $25,700. So 25% of that would take us to $6,750. And with that, I turn it back over to you, Rodney. Thank you very much.
All right, thank you, Mr. Miller. Ms. Bartell, anything to add before we conclude the presentations?
Yes, Mr. Romano, just a brief rebuttal. Thank you so much. So just to address a couple of points that Mr. Miller brought up. One, I want to point out that there was no latch on the actual doggy door preventing the dog from going through the door and leaving the home. Number two, there was no fence around the property at all. And
I would object, Rodney, I apologize. I don't normally do that during a rebuttal, but I would object on relevancy grounds. In order to knock on the door, Ms. Jones would have had to enter through a gate if there was one present. So the absence of a gate, I would argue, is completely irrelevant.
Okay, Ms. Bartel?
Yes, Mr. Romano, it is absolutely relevant. Number one, it goes to background in terms of setting the scene. And two, it also goes to the overall negligence of the defendant in this matter. Not only was the doggy door unlatched, but there was no fence. So that dog could have escaped and simply run wild around the neighborhood. So the information is relevant to the jury.
Okay, thank you. I will reserve ruling, and I will respond to that objection and the response in my final decision. Thank you.
Just another brief points that I'd like to make, Mr. Romano. We heard Mr. Miller say earlier that this type of incident had never happened before, that Ms. Jones had been to the home multiple times without incident with respect to the dog, and that when my client knocked on the door, that Ms. Stevens, the defendant, was frightened and sent her dog for protection. Well, we know that the front door was locked. She knocked on the door. She didn't come busting through the door. There's no evidence that anybody intruded into the actual home. And so to essentially stick your Rottweiler, your 80-pound Rottweiler, on somebody that is simply knocking on your door is just completely unreasonable. We also saw a few images in Mr. Miller's presentation, the social media images. Now, what we don't see in those images is the pain that Miss Jones was in after each one of those activities. We all know that everybody posts only the good things on social media. That's exactly what Miss Jones did here. We also know that just because somebody is involved in an accident or sustains an injury, it doesn't mean that they're supposed to stop living their life because they were injured. And Miss Jones is certainly not going to stop living her life because of this injury. She simply has to do it with restrictions. So with that being said, I'd like to conclude my presentation and thank everyone for being here.
Thank you, Ms. Bartel and Mr. Miller. I will excuse you at this time and begin my deliberations. Thank you.
This last segment, Arbitrator Romano has dismissed the parties and counsel from the hearing. If this were an actual arbitration, he would simply deliberate in private and render his award. All that the parties would know about why he ruled the way that he did would be contained within the four corners of the award document itself. This is why, as he discusses, he tends to include some of his reasons for his decision in the award. Here, however, for educational purposes, he's going to give us the benefit of explaining his deliberation process and then walk us through the award.
All right, thank you. Once I've let the parties go, I go immediately into my deliberations. I gathered the documents that I've been given to review, and I try to encourage my clients to give them to me in digital form, just so that I can manage it better. And then I start reviewing the documents, the excerpts that they've invited my attention to, and I read whatever else I think I need to for context. And I begin to note the areas of agreement and disagreement. And then with regard to that which we agree, I leave that alone and go on to the areas of disagreement. First, trying to find out whether plaintiff or determining whether plaintiff presented a prima facie case, covering the elements of negligence, in this case, negligence, causation, and damages, or duty, breach, causation, and damages. And then I'll go through the prima facie case. And if one's been established, then I go through the defenses in the case, analyzing each of those, why I accepted them or why I rejected them. And then I go through the causation. In this particular case, causation was not an issue. It was clear that the injuries were caused by the dog, and it was not an issue. So in a case where causation would be an issue, it's usually disputed through experts, or often disputed through experts. And so I go through an analysis of why I found one expert to be credible and the other not to be credible, based on the Florida standard jury instruction on credibility or believability, meaning their their level of expertise and their whether they were in the position to know the facts the best, or whether they had the full facts, and so on. Once I'm done with liability and causation, I go on to comparative negligence. I'm sorry, liability, then comparative negligence, and analyze comparative negligence. And I always make a point in my decisions that 10 different people could reach 10 different conclusions on whether there's comparative negligence, and if so, the apportionment. It can be anywhere from 1 to 99%. And so I do my best to show that this is my opinion based on my experience and background, but I understand that other people, other reasonable people, could disagree. And then I get to the damages and evaluate the 6 elements of damages in a negligence case, which are past medical bills, future medical expenses reasonably to be incurred, past lost wages, future lost earning capacity, past pain and suffering, and future pain and suffering. And of course, pain and suffering includes mental anguish, disfigurement, the loss of enjoyment for the capacity of life, and the like, for the quality of life. And next slide. And so in my decision, I begin with introductory paragraphs. There are a couple of introductory paragraphs that go into all of my decisions, which just outline the burden of proof, the elements of damages, and the rules of the road for non-binding arbitrations, and the statutes and the rules of civil procedure that apply. And I always give a reasoned opinion unless the parties ask me for a verdict or a simple decision. I think a reasoned opinion gives the parties more to talk about with their clients when they're deciding whether I've made a reasonable, well thought out decision, or whether I've gone completely off the rails and might not be looking at the case they're looking at. Those are important things for them to consider. And so I try to give them the best possible product that I can. I again, as I mentioned, I identify the agreed issues and only address disputed issues. Those are the rules for arbitrators in Florida. I explain what evidence I found credible and why, and what evidence I found incredible and why. I address all the elements of the prima facie cases and the defenses, as I pointed out earlier, and then I sign and date the award. Next slide. And then I file the decision on the same day, and this is very important. It must be filed on the same day as it is published to the parties. I publish it by email to the parties within minutes of filing the decision through the e-filing portal, which of course all attorneys are required to use the e-filing portal for the filing of pleadings. And that's the end of the process. Okay, let's move on to an actual non-binding arbitration decision so you can kind of get a look at what the format is and how I lay it out. There's no pride in authorship here. You can lay out your own however you wish. So this is just one idea that works well for me. First, I double check the style and the jurisdiction to make sure that I have these things correct. And I always want to double check the case number just to make sure that I haven't mistyped anything. And then I have the title and my name and the names of counsel. And I will typically, didn't do it here, but I typically will list anyone else who appeared at the mediation, or I'm sorry, at the arbitration. And then I make a list of the documentary evidence that was presented for review. So that could be medical records, police reports, photographs, any documentary evidence, and also depositions that I have been given for review. And again, I don't read depositions in advance because, you know, the first 15 pages of a deposition could be background and qualifications of a doctor that I'm very familiar with. And I don't think it's right to charge people for me to read stuff like that. So I wait until the attorneys make their presentations. I tell them this in advance when I send out my guidelines. so that if there's something they really think I should read in advance, they'll tell me and I'll do that. Otherwise, I wait until they invite my attention to certain excerpts. And then, of course, the introductory paragraph saying when the matter came before me, confirming that everything that was provided to me was also provided to opposing counsel, and confirming that each side presented oral testimony and documentary evidence, as well as arguments supporting their respective clients' positions. And then upon consideration of the evidence and arguments of counsel, I find as follows. Standard paragraph is number 1, where I lay out what the arbitration standard is. And I believe that I'm correct in saying that the arbitrator's role is to decide the case as if it were a bench trial. You may not decide the case based on what you think would be a number they'll both probably accept. That's a mediator's number or a silver bullet and can be done, but not as an arbitration decision. That's a totally separate dispute resolution tool. Nor is it a guess of what a jury will do. It is my view of the case, and that's all it is. There's discussion that the rules of evidence are relaxed, but nobody has any guidance from the Supreme Court right now what that means. I interpret it to mean relaxed as to authenticity. So I don't require records custodians to confirm that the records are what they are. If the attorneys represent them to be what they are, I believe a member of the bar should be believed until they're proven to be not a believable person. And so, so the only way I reduce or relax the rules of evidence is authenticity. Otherwise, I don't consider anything that would be inadmissible, but I will consider something that's not in admissible form, but will likely be put into admissible form. A good example is a CME or a compulsory medical exam report. We know that that doctor will be bound to whatever it is he or she put into his report. And so that's a reliable source of information, even though it's not currently in admissible form. Hopefully that makes sense. Then I go on to standard paragraph number 2, which goes into all of my decisions. Just again, for the 3rd or 4th time, reiterating the statute and the rule of civil procedure that applies. And then I put this disclaimer as number 3 to be absolutely sure that attorneys don't get themselves in trouble by thinking, okay, it's over, I'm not going to take it, so I don't have to do anything. A non-binding decision becomes binding if nobody rejects it in 20 days. And so then I go to paragraph 4, which is specific to this case, and give the background of the facts and circumstances that gave rise to the cause of accident of the cause of action. And I put in the things that are undisputed. So, for example, that the plaintiff was drunk at the time, that the defendant did not have a bad dog sign posted on the property, and so forth. Then I move on to an analysis of liability. In this case, there was a statutory analysis, and I found that the statute did apply, and that there was no evidence under these circumstances that the plaintiff's conduct provoked the dog. And so I did not find that the plaintiff was a trespasser in this case, since there was no agreed upon window of time. If, for example, the landlord said, I want you to deliver the money to me in cash, in person, at my back door, but only after 9 in the morning and before 6 at night, I might have found that the plaintiff was a trespasser, but those weren't the facts of this case. So I found for the plaintiff as to liability, and then moved on to paragraph 6, which is comparative negligence. And I reasoned that pounding aggressively on someone's back door is going to cause the dogs to bark. I have lots of dogs, and that's what always happens. I think that's within the common experience of people. However, I felt that most of the fault rested with the defendant, because if you allow your dog to bite somebody, you better have a good reason to do it. And there's no evidence in this case that the dog was trained to bite or not bite on command. And so I assumed that the dog was just a pet that would do whatever it wanted to do, but not that it was trained like a police dog. And then I move on to causation, and that was a very short analysis because it was undisputed that the dog, that the injuries claimed were caused by the dog. What was disputed is how bad they were and how long they would last. And I did notice, for example, Mr. Miller made an objection to the future medicals because the doctor's opinions were all based on possibility and not within a medical degree of probability or certainty, which is the standard in Florida. And so I discounted all of the doctor's opinions on future medicals. And then I rendered my decision. And I had found, as you noted above, 25% comparative negligence. And so I added up all of the elements of damages. And I like to list all of the elements of damages, even if I'm awarding zero, just so it's very clear that I considered those things and didn't accidentally leave them out. And then I totaled them up, multiplied by the defendant's share of responsibility, and came up with the verdict of 62,750.98. And then and what I do too is, because oftentimes I publish these at night, and I want to be certain, you know, if I publish it on the today at 8 p.m., today doesn't count as one of the days for the 20 days because it's after business hours. So I usually put in not only the date that I published it, but the time, so that the judge can accurately count the number of days if somebody files a notice to enforce after 20 days.
So that, in a nutshell, is the non-binding arbitration hearing process. We hope you found this video to be enlightening, and it's our wish that the information will prove useful to you as you encounter non-binding arbitration in the future. Thank you very much.